All right.
Hearing in the appeals, Martin and Her Majesty's Advocate and the Advocate General for Scotland and Miller and the Procurator Fiscal.
Sorry, this is one of the disadvantages of coming into an assembled court. We don't have time to sort our papers out.
Are there many disadvantages? Okay, so we do know. Okay.
Yes, who begins? Mr. Chair?
Yes, thank you, Lord. Lords, I appear together with my learned friend Mrs. Delavigovich-Broom and Miss Mitchell. The co-appellants are represented by my learned friend Mr. Brown, assisted by Mr. Devlin. The Advocate General appears together with my learned friend Mr. Muir. The Advocate General...
I think he's just visible from where I'm sitting.
I'm sorry, Lords. The Advocate Deputy and the Advocate General appears for his own interest together with my learned friend Mr. Lindsay.
Now, we have a list of hours which seems to exceed by some margin the time available. But I take it that the Advocate Deputy and the Advocate General's 2 hours are not to be added together. You'll take 2 hours, is that right, to reply to the...
Lord, that is correct. I would say, however, that my 2 hours is more an hour to an hour and a half.
Right, and that would be in toto for both cases. We're really taking them as one, effectively. And Advocate Deputy, is that your position too?
I would anticipate being something of that order myself for the two appeals.
Yes. And would it be convenient if we, I don't know how the division is between you, Mr. Shedd, and Mr. Brown, but it would seem better that you both address us first and then we proceed to the law officers. Is that what parties were anticipating?
Yes, it was, as I understand it, Lord.
Yes. Good.
Is there any difference at all between the two cases? I haven't detected it.
I don't believe so, my Lord. No material difference one with the other.
So why are we going to hear both of you?
Well, I suppose it would be a matter for your Lordships to consider how best the procedure should be regulated. It's in deference to my Lord and the Chair's indication, I think.
Well, I was hoping we wouldn't take 5 hours for the pair of you.
No, Lord, I'm slightly perturbed to hear my Lord indicate the position in relation to the proposed timings. In fairness to parties, my Lords, I think it was thought that the timings might be worked out on the basis that the appeal might start at 2 o'clock today and tomorrow would be available if necessary.
I see.
And I think that, as I had done the arithmetic, my Lords, those timings were to fit within this afternoon and tomorrow.
I see.
But it may be that your Lordships have received a message which suggests a rather more alarming vista.
Well, let's proceed in that way. That what we'll do is we'll hear you, and then Mr. Brown can add anything he would like to add, and then we'll proceed to the Advocate Depute and then to the Advocate General.
Mr. Chair, this is a cavernous space.
Yes, my Lord.
So you really have to raise your voice, because it's no good pretending that the loudspeaker system worked, does it?
I'll do my best to assist them, Lords, if I may. As your Lordships will be aware, the issue in the appeal is whether Section 45 of the Criminal Proceedings, ECHR Reform, Scotland Act 2007, in so far as it increases or purports to increase the maximum sentence on summary conviction for a contravention of Section 103(1)(b) of the Road Traffic Act 1988, as amended, is within the legislative competence of the Scottish Parliament. And My Lords, I think we'll have seen the issue set out in the Statement of Facts and Issues, which my Lords will find, I hope, in the bound volume at tab 2.
Yes.
Lords, if I could say just a very little about the immediate background to Mr Martin's case before inviting your Lordship's attention to the terms of the Scotland Act. Lords, before the passing of the 2007 Act, the relevant penalty was provided for by Part 1 of Schedule 2 to the Road Traffic Offenders Act 1988. And my Lords will again find reference to that in the bound volume at tab 2 at page 5. And at summary level, the penalty was 6 months. So the practical territory that the appeal crosses, my Lords, is the difference between the penalty as it stood 6 months and the penalty as it now purportedly is 12 months.
It was an either-or type of offence, wasn't it, in the sense that it could be prosecuted either summarily or on indictment?
Absolutely, my Lord. There was specific provision in respect of Scotland for the offence being tried either way, though I understand from the helpful researches undertaken by the Lord Advocate that there's an indication in the papers that the position was not so in England. But in any event, as my Lord and the Chair points out, so far as Scotland was concerned, that was absolutely the position.
So it couldn't be a prosecution and indictment in England?
That's my understanding, Lord. So, the Lords will know the facts so far as relevant, very briefly stated, are the appellant pled guilty to 2 charges of driving while disqualified. Those were committed in December 2007. And in respect of those charges, he was sentenced to 12 months imprisonment. The charges were committed while he was on bail, and so he received a sentence of 8 months in respect of the substantive offences and 4 months in respect to the bail aggravation.
Yes.
His bill of suspension, Lords, was dismissed by the High Court of Justiciary on the 6th of January of this year, no argument having been heard. My Lords will be aware from the papers that there had been an earlier cases heard in the summer last year by the High Court of Justiciary, which raised similar points. At that stage, my Lords, it was perhaps anticipated that the present appellants would be heard at the same time, but for practical reasons that didn't occur.
Yeah. And just to be quite clear, a bill of suspension is a means of bringing under review of the High Court decisions of the Sheriff Court.
Absolutely, my Lord, and it's classically regarded, if it's of assistance to the court, as being deployed in this context where there's a challenge to the competence of the sentence.
Yeah.
And that's why it's the vehicle which has been adopted by both appellants in this case. Now, my Lords, it is, as I understand it, a matter of agreement that the road traffic legislation is a reserved matter within the meaning of Part 2 of Schedule 5 to the Scotland Act, and that the appellant was subject to the enhanced penalty under Section 45 of the 2007 Act at the material time. Now, my Lords, therefore,
Did you start serving your disqualification? Or, sorry, no, what am I going to do? Did you go to prison or anything?
Yes, my Lord, and he has served some time in that sentence, being admitted to interim liberation, I think, in March. I'll have the precise date checked, my Lord, if I could. He served.
Why was he released? When, after we gave leave or something? Or after leave was given?
No. I'll need to check the precise timing, my Lord, if I may, just to come back to my Lord about that matter. It's not uncommon, my Lord, when an issue of competence about the sentence is raised for the High Court to consider admitting someone to bail pending the determination of their bill of suspension.
So did the High Court make an order?
Yes.
So somebody applied for it, presumably your client applied for that and was given
the
interim
appellant
liberation.
has to apply for interim liberation pending the disposal of the bill.
Yes.
And that occurred in this case, my Lord.
I mean, you were sentenced on the 17th of December 07,
Yes, my Lord.
but you didn't get leave until January 09, is this it?
Absolutely, my Lord. That was a practical reason effectively connected with the hearings in the other cases in July last year. But to answer my Lord's question about the date of interim liberation, Mr Martin was granted interim liberation on the 28th of March 2008.
He was bailed on the 20th of March 08?
28th, my Lord, of March 2008.
Oh, sorry, yes, that's called interim liberation, is that it?
Yes, my Lord.
I see, okay.
It's not uncommon as a generality, Lord, for those who use this mode of appeal to apply for interim liberation, pending the court considering the merits of the bill.
And it sounds as though the sequence of events would be that interim liberation would be granted, a date fixed for the hearing of the bill of suspension, and then you've explained what happened then, and the order was not recalled because it was indicated that the matter would come before this court?
Lord, when the bill called for before the High Court of Justiciary in January 2009, the bill was dismissed, but at that stage the Crown did not seek a warrant for his re-imprisonment.
Right. Which
would, as my Lord and the Chair certainly and my Lord Rodger would bear in mind, was a common enough practice, but on that occasion the Crown did not do so. As my Lords know, there was subsequently a hearing for seeking what was then leave to appeal to the Judicial Committee, the Privy Council, before the High Court of Justiciary, and as my Lords know, leave was then granted.
Yes.
And my Lord, as against that background, very helpfully and very properly, the Advocate Depute did not move for the recall of interim liberation, since the matter was coming before your Lordships.
Yes, thank you.
You didn't appeal against the sentence as such?
Not as such, my Lord. The bill of suspension is directed to this issue alone.
So it's entirely competency.
Indeed so, my Lord. Though perhaps, since your Lordships are raising these questions, I might indicate my understanding is the Sheriff reduced the sentence in recognition of the fact there was an early plea of guilty.
Reduced it because of what?
The fact that there was a plea of guilty, my Lord, in this case.
Yes, yes.
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 My Lords, perhaps the most important provisions of the Scotland Act for present purposes, if I may respectfully suggest to your Lordships, are Section 29, Section 101 and 126, and Schedules 4 and 5, particularly paragraphs 2 and 3 of Schedule 4 and Part 2 of Schedule 5. Lords, I understand that those provisions at least have been reproduced for your Lordships' benefit in Volume 9 at tab 107 of the volumes.
I can't mark it up every time.
We've really got 9 volumes of authority. No, we've got 10.
Yes, I think we can start looking at the Act.
Yes, indeed. The Lords have the benefit, I hope, of the whole Act reproduced. Lest your Lordships have to regard other sections as important, but perhaps I could take my Lords first to Section 29. The Lords will see that subsection 1 provides that an Act of the Scottish Parliament is not law so far as any provision of the Act is outside the legislative competence of the Parliament. And then subsection 2 provides very broadly the circumstances in which a provision might be said to be outside that competence. And Lords, again, I think it's a matter of common ground in this case that your Lordship's attention is directed to subsection paragraph B and C.
Subsection 2.
Subsection 2, my Lords. And subsection 2b, my Lords will see, renders a provision outside competence if it relates to a reserved matter. And the other potentially significant restriction is in subsection C, where my Lords will say a provision is also outside competence read short if it is in breach of the restrictions contained in Schedule 4. The other matters are not relevant for present purposes.
Well, subsection 3 is helpful, isn't it, because it tells you a little bit more about 2B.
Absolutely, Lord, I'm very much obliged. The subsection 3 appears to be pointing your Lordship's attention to how the question of whether a provision relates to a reserved matter should be adjudicated. And my Lords will see, for the purposes of this section, that is section 29, the question of whether a provision of an Act of the Scottish Parliament relates to a reserved matter is to be determined, subject to subsection 4, by reference to the purpose of the provision, having regard, among other things, to its effect in all the circumstances.
And then subsection 4, which may be thought to cast further light on what is meant by B.
Absolutely, Lord. It provides a provision which would otherwise not relate to reserved matters, but B, makes modifications of Scots private or Scots criminal law as it applies to reserved matters, is to be treated as relating to reserved matters unless the purpose of the provision is to make the law in question apply consistently to reserved matters and otherwise. That, of course, more the structure of the section. Lords will also be aware that relevant, therefore, for present purposes are the provisions of Schedule 4 to the Act.
Page 70.
Page 70, Lord, yes. Thank you, Lord. And the Lords will there see that Schedule 4 is headed enactments, etc., protected from modification. And Part 1 deals with particular enactments which are so protected. And the Lords will see that those, of course, include the Union with Scotland Act and the Union with England Act and the European Communities Act and the Human Rights Act, amongst others. The Lords will then see that so far as the law in reserved matters is concerned, paragraph 2 provides that an Act of the Scottish Parliament cannot modify or confer power by subordinate legislation to modify the law on reserved matters. And my Lords will then see that there is a definition of the law on reserved matters provided in the next paragraph, and in 2A, that is to the effect any enactment, the subject matter of which is a reserved matter and which is comprised in an Act of Parliament or subordinate legislation under an Act of Parliament, and B, any rule of law which is not contained in an enactment and the subject matter of which is a reserved matter. Lords will then see that paragraph...
Is some of this directly relevant? What's your submission on this one? I mean, have we got a law on a reserved matter here?
Yes, Lord, is my submission.
So which of the words we want to underline?
Well, Lord, as I would invite my Lords to direct their attention to 2A, because the law on reserved matters falls within 2A in my respectful submission, an enactment, the subject matter of which is a reserved matter, and, Lords, for present purposes, that is the relevant penalty provision of the Road Traffic Offenders Act of 1988. And I respectfully submit to the Lords that meets the test set out in 2A.
I see.
What does the subject matter mean in that context?
Well, Lord, in answer to that question, I would submit that a relatively straightforward interpretation can be applied to that. Lord, reading the matter short in this context, the Road Traffic Offenders Act and the Road Traffic Act are reserved matters within the meaning of the relevant schedule of to the Scotland Act. And therefore, in my respectful submission, what your Lordships are here concerned with is an enactment, that is particularly the Road Traffic Offenders Act, the subject matter of which is a reserved matter. And in my respectful submission, Lord, it does fall within that definition.
Are you saying that extends to penalties as well as the substantive provisions which prohibit certain things?
Yes, Lord. Paragraph B, Lords, it has been contended in at least academic analysis is designed to deal with common law rules.
So paragraph which?
2B, Lord.
2B, okay.
So you say we're not concerned with 2B?
No, Lord.
And we're concerned with what's we found in Schedule 5, E1
D, is that right?
Yes, my lord.
Sorry, Schedule 5 what?
Page 83, in the print I'm looking at. Section E1D, the Road Traffic Offenders Act, 1988.
Yes, I'm most obliged, my lord, thank you. If it's any assistance, my lords, I don't understand this point generally to be controversial.
There, we might as well.
Yes, of course.
Just identify where we're going. Where we are.
Absolutely.
Should we go back to Schedule 4, paragraph 2, subparagraph 3?
Yes. My lords, if I can take my lords therefore to that.
I'm terribly sorry. I mean, just the subject matter of is page 83. How do we get into this subject? Where's the lead into to page 83? I mean,
My lord may see that on page 83.
no, I do see that there is a heading and it says the subject matter of D and then our 1988 Act. But I mean, I don't quite know what.
Section 30 is the one which gives rise to the schedule.
Yes.
Section 30, subsection 1 defines reserved matters.
Ah, that's it. So it's section 31.
30, subsection 1, yeah.
30 subsection 1. Schedule 5. By the time you get to section E1, what is it E1 of? I mean, where's the lead in? Part 2, specific reservations. Is this it?
Lord, E1, if I can assist in any way, my lord, is part of Schedule 5, which deals specifically with reserved matters, as my lord Rodger of Elsewhere has pointed out.
How do you get to E1?
Specific reservations, part 2. Specific reservations, part 2.
Part 2.
Yeah. Of the schedule.
It's page 76, my lord, I think, it's part 2, specific reservations, and then they're enumerated under various heads.
Yes, it's paragraph 1 says the matters to which any of the sections in this part apply are reserved matters for the purposes of the Act.
You need that, don't you?
Yeah.
Yeah.
And next one, paragraph 2, a section applies to any matter described or referred to in it when read with any illustrations, exceptions, and so on and so forth. But we're really concerned with paragraph 1, and all of this takes us back to what 29.2b is dealing with when it says relates to reserved matters.
Yeah.
Absolutely.
You need to know what that is.
Yes, indeed.
But before we leave Schedule 5, should we just bear in mind to subparagraph 3?
Schedule 5, we can say.
Because I think that is in play.
Yes, indeed, Lord.
This is Schedule 5, page 71. Paragraph 2, subparagraph 3.
Yeah.
Yes, indeed, Lord. And if I could just remind my lords, therefore, that subparagraph 1 applies in relation to a rule of Scots private or Scots criminal law, whether or not contained in an enactment, only to the extent that the rule is special to a reserved matter, and the other aspect of the matter is not immediately relevant for present purposes.
And that falls to be read, I think, with the definition of Scots criminal law on page 61, which is in section 126, subsection 5, which I think explains that Scots criminal law includes, amongst other things, penalties.
Indeed.
Which is what you're concerned with.
Absolutely. Laws will see that's not an exhaustive definition in 126 subsection 5, but it certainly sets out a number of specific matters which include penalties.
Mr. Chair, if one looks at section 29, too, I mean, I'm just trying to get my bearings on it because one is aware of the complications of this subject. Do I take it that something is out of competence if it relates to a reserved matter, but is also out of competence even if it doesn't relate to reserved matters, if it is in breach of the restrictions in Schedule 4?
Yeah.
Precisely.
So it's not enough, so to speak, that you escape from B. You've also got to escape from C, is that right?
Correct.
From the point of view of the legislator.
Absolutely, Lord. And then that's a submission I make on the appellant's behalf.
So a lot turns, I would suggest, on what is really meant by relates to in
Indeed.
section 29 2b, because if I understand the system correctly, if you're able to get within 2b, then you're home and dry, aren't you?
Yes, indeed, Lord.
But it may be said, indeed it's said against you, it doesn't actually relate to reserved matters, and therefore you have to try to find a solution in little c, which takes you to the schedule.
Yes, indeed. So, my Lord, I wonder if I just could, my Lord, before I seek to address that, if I, on behalf of the appellant, if I could also just mention to your Lordships, so far as Schedule 4 is concerned, before your Lordships, as it were, leave it for the time being, that as well as the sub-paragraph of paragraph 2 read to your Lordships, there's also paragraph 3, which may be relevant. And my Lords will see that paragraph 2 does not apply to modifications which are incidental to or consequential on
Yes.
provision made. And my Lords will see the first aspect in A is incidental to or consequential upon provision made which does not relate to reserved matters, and B, do not have a greater effect on reserved matters than is necessary to give effect to the purpose of the provision. And if I could just also mention to your Lordships, my Lord and the Chair has already alluded to section 126, which is the interpretation section. I could just draw attention, my Lords, if I may, to the fact that on page 60, my Lords will see that enactment includes an act of the Scottish Parliament, the Northern Ireland legislation within the meaning of the 1998 Act, and an enactment comprised in subordinate legislation, and includes an enactment comprised in or in subordinate legislation under an Act of Parliament whenever passed or made. My Lords will also see...
Have we got any subordinate legislation in play here?
Well, Lord, it depends on one's view, as I understand it. One view of the matter, Lord, is that all the provisions, in particular section 45, is subordinate legislation, even though made by the Scottish Parliament.
Well, that hardly squares with the definition of subordinate legislation at the top of page 61, does it?
No, I appreciate that, Lord. Certainly from the perspective of the Human Rights Act, acts of the Scottish Parliament are defined as subordinate legislation.
Yes.
Mm.
Yes, they are.
No,
But for that,
Yes.
yes, for the purpose of that Act, Lord, and appreciate your Lordships required to be guided by what is said here. If I could also mention to my Lords, for what it's worth, the word modified also appears appears in the interpretation section, and that, as my Lords will see, includes amend or repeal. And the Lord Walker has already called attention to the specific definition of subordinate legislation at the top of page 61. And the Lord in the Chair has noticed subsection 5.
Are you able to direct me to the provision in Schedule 2 of the Road Traffic Offenders Act 1988, which I think is printed in full in volume 8, tab 104, so that we can actually see the layout of the provision we're dealing with?
Yes, indeed.
Which page?
My Lords, if I can draw my Lord's attention to, it's the Road Traffic Offenders Act, which, as my Lord observes, is at that tab. My Lords, it's in tabular form at page 4403 of the statute.
Yes. And so we see the section of the Road Traffic Act itself, 103, which is a relevant section
Yes.
for our purpose, and there is a different system for Scotland as compared with England and Wales, in that, as I understand it, the only method of prosecution in England and Wales is summary prosecution.
Lord.
And then we can see in Scotland there are the alternatives at the bottom of the page.
Absolutely.
And what's effectively happened, I suppose, is that under the punishment section, for 6 months, you now read 12 months, if the provision is competent.
Yes. As it happens, Lord, it's a doubling of the existing penalty.
I'm sorry?
As it happens, it's a doubling of the existing penalty.
But not as far as the indictment is concerned. That remains untouched.
Absolutely.
So the only change is a change from 6 in little b, is that right, against the summary prosecution?
That's right.
So in Scotland you can get 12 months for this. In England you can't get more than 6.
Correct.
Is that right? On the, or even on the existing, on the pre-amended version, is that right?
Yes, in the pre-amendment version, Lord, one could only be prosecuted at summary level for this offence in England and Wales, and that was the penalty as provided for in the schedule for the Road Traffic Offenders Act.
Sorry, how much can you get in England and Wales summarily for this offence?
6 months, Lord.
That's the maximum, is it?
I understand so, Lord.
I mean, is this table, unlike almost every other provision in the criminal law, escaped amendment since 1988? I seem to remember having a version of it, these things at hand, when I was Lord Justice General, which had lots of changes in them.
The Road Traffic Act, Lord, and possibly the Road Traffic Offenders Act, as I'm trying to answer the Lord's question immediately, did undergo amendment, Lord, but so far as...
Not at all.
But not at all so far as this is concerned, as I understand.
Somebody's very kindly set out in the Statement of Facts and Issues in your case on page 5, the very table we're looking at, I think, which doesn't contain any indication of amendments on this provision.
Amazing.
I hope, I mean, that seems to be agreed. I hope it's correct.
I will make efforts, Lord, to
I'm sure you'll be right,
that,
Mr. Shedden.
I think it is. I think it's one of the matters which is common ground in the appeal.
So the effect of this, therefore, is that in Scotland you can get 12 months summary, whereas in England you can only get 6.
Yes.
Good. Well, after that introduction, where do we go next?
Well, I think in deference to the helpful indication the Lord and the Chair gave a moment or so ago, as my Lord says, perhaps the first logical approach is to look at 29(2)b to ask whether the provision relates to reserved matters. And as your Lordships have already noticed, subsection 3 provides guidance on how that question should be addressed. And my Lords will see again the question whether, reading short, a provision of the Act of the Scottish Parliament relates to a reserved matter is to be determined, subject to subsection 4, by reference to the purpose of the provision, having regard, among other things, to its effect in all the circumstances.
Sorry to interrupt you. You mentioned section 101. I'm not sure you took us to it. Did you?
Oh no, I'm terribly sorry. Well, perhaps I ought to.
I mean, I don't know whether you want to now or not, but
perhaps
it was part of the programme you announced.
Perhaps it would be convenient, Lord, just to mention that. Oblige, Lord. That's at page 48 of the Act, as reproduced for your Lordships. And my Lords will see that subsection 1 makes it clear the section applies to any provision of an Act of the Scottish Parliament or of a bill for such an Act, and any provision of subordinate legislation made, confirmed and so on, which could be read in such a way as to be outside competence. And subsection 2 provides that such a provision is to be read as narrowly as is required for it to be within competence, if such a reading is possible, and is to have effect accordingly. And
is that equivalent to section 3 of the Human Rights Act?
Not precisely, my Lord, as I understand it, because, of course, it deals with this particular subject matter which your Lordships are presently considering, as opposed to simply dealing with questions of reading legislation compatibly with convention rights, which is... But
the word narrowly doesn't appear in the Human Rights Act.
Right. No, indeed not, Lord. And I understand, my Lord, and the Chair made certain observations about that in the case of DS, which are set out in the Appellant's case, which I was intending to come, Lord. But in deference to your Lordships, if it's assistance by way of framing the discussion, it again appears to be common ground in the appeal that if the Appellant's contentions are soundly based, or any of them are, then your Lordships would have to consider what effect section 101 subsection 2 had on section 45.
Yeah.
And you would say it be read in such way as not to affect the Road Traffic Offenders Act, is that right?
Yes, indeed, Lord. And again, as I understand it, Lord, it's common ground amongst the parties that, although the formulations, I think, are expressed rather differently in the written cases, that section 101 subsection 2 could be deployed in broadly that manner. So there doesn't seem in this case, Lord, to be contentious. So if the appellants were right in their contentions, to which I'll come, Lords, then your Lordships would be directed to section 101 and then subsection 2. And as my Lord Rodger helpfully observed, so far as the appellant is concerned, it would, on the face of it, Lords, lead to the practical result contended for on behalf of Mr. Barton. Now, my Lords, then, if my Lords are then considering, in the first instance, section 29, subsection 3, your Lordships are enjoined to consider whether, by reference to the purpose of the provision, whether it relates to reserved matter. And the language that my Lords will see in subsection 3 makes it plain that your Lordships, in doing so, have to have regard to its effect in all the circumstances. It seems plain that your Lordships may have regard to other things which are not set out and enumerated, but in my respectful submission, the one thing that your Lordships must have regard to in this context is the effect in all the circumstances of the provision.
Well, I mean, that's perhaps rather unsurprising, because the effect is likely to reveal the purpose, isn't it? Subject to the law of unintended consequences.
Well, I see the force of that, my Lord, and it may be that other aspects of the Scotland Act are, in this context, are designed to deal more precisely with the unintended consequences that my Lord draws attention to. But
and can one take account of things it doesn't affect as well as what it does? I mean, to just come out of the thicket in a way, what I'm thinking about is what it doesn't do is increase the penalty on indictment, and therefore the overall, the maximum sentence available for this offence in Scotland is not increased.
Absolutely, Lord, and certainly Lords are enjoined to consider its effect, but in all the circumstances.
Yes,
and presumably that is not designed to restrict your Lordship's consideration to the relevant circumstances as they present themselves to your Lordships.
So can I make sure I got the hang of this? I mean, in Scotland, pre-amendment, maximum 12 months, only 6 on summary, but if you go on indictment, you can get punished, you can get sent down for 12 months, right?
Correct, Lord.
Post-amendment, still 12 months maximum, but all of it can be given summary.
Correct.
Who decides whether to go on indictment?
The prosecutor decides that, Lord. That's a matter, at least traditionally, for his or her unfettered discretion.
I see. And post-amendment, I mean, given that the entire sentence maximum is available summarily, why would the prosecutor want to go on indictment?
It's a very important question, Lords. As I understand it, the Lord Advocate in her printed case suggests that it's part of the overall reform which the 2007 Act was designed to bring about, to allow prosecutions to take place at summary level, which is quicker and cheaper generally than prosecution and indictment.
But, I mean, you do get prosecutions. I mean, she still might wish to include a charge on, I mean, unless the practice has changed radically, she might include it in the connection where there's other charges on indictment, and this was just one of the ones which was on, and it might be necessary, for example, to have it for even just for evidential purposes, but you put it on an indictment in that kind of situation, and then a penalty can be imposed, and 12 months is it. So it can be used in that kind of situation.
Well, I'm obliged, my Lord. I don't obviously
I
divert to
suppose,
that.
yes, and if you commit 2 offences, you'd have to go with you on indictment?
No, Lord, the present appellant whom I represent, I regret, committed 2 offences within a few days of each other and appeared on complaint.
No, but I mean, therefore, but if that had gone on indictment, he could have gone down for 2 years.
No.
Yeah.
Well,
Yes, two separate offences, yes.
They might be made concurrent, but
So that
Well-
might have been so that would have put him at greater risk to go on indictment.
If that were the proper view of the sentence, my lord, the difficulty is it might raise a technical question of Scottish sentencing procedure about whether if one is prosecuted with 2 charges on 1 indictment, one can be sentenced to more than 12 months.
And there was some question in your case, you were on bail or something.
Yes, Lord.
So if you were on indictment, that would increase too, wouldn't it?
Yes, indeed, Lord. There's a separate penalty provided for a bail aggravation. So if an offence is committed while on bail, one can be exposed to a significant additional penalty for that matter alone.
But does that depend on whether you're being prosecuted summarily or on indictment?
No, my Lord, one can receive a separate penalty in respect of prosecution on indictment or on complaint.
What I'm wondering was, there's a maximum set for that particular offence, and does it remain the same whatever level you're being prosecuted?
I think, Lord, I'll need to double check whether there's a variation really so far as summary and solemn prosecutions are concerned in respect of bail aggravations. They're all regulated by the same section of the Criminal Procedure Scotland Act 1995 now, as I recollect it.
Was there any pattern of electing to prosecute on indictment in order to obtain access to the enhanced penalty?
I think it's fair to say there was, my Lord, in circumstances particularly perhaps where someone, those accused had a record for comparable offending. Well, I think it's fair to say before the change that the emphasis, I don't speak for the Lord Advocate who's ably represented here, but I would understand from practice, my Lord, that it was not uncommon to use prosecution on indictment for those whose records involved analogous offences.
Much the most common situation would be where, for example, it's causing death by whatever it's called, dangerous or whatever it's called, reckless driving. And you also, the person, as often happens, is driving without uninsured or whatever it is. You have all these offences on.
Yes.
That's the kind of situation where you tend to find these things.
Yes, and as I would understand it, was if the court was concerned only with a contravention of driving while disqualified,
right,
then prosecutions and indictment tended to follow when those accused had records for comparable offending.
And as far as the purpose of the provision is concerned, you've explained already that it was to enable cases which previously had always been taken summarily to be taken on indictment to be taken summarily because of the increased penalty. But it would be right, wouldn't it, to look at the whole purpose of the reform, because it was relieving the sheriff of the High Court of certain things, and it was also affecting the sentencing power for district courts. Is that not right? I mean, one's got to look at the entire structure of the McInnes report, I think it's called, to understand what was being legislated for here.
Lord, I suppose if I could make 2 observations in response to my Lord's question. The background in terms of the McInnes report and the legislation is not, in general terms, of course, any subject of dispute before your Lordships. What, of course, may be a question of emphasis for the resolution of the appeal is nevertheless whether your Lordships are focusing on the background as context or rather more substantively than that. Because, of course, your Lordship's attention is drawn in section 29 to focusing down on a single provision of an act if necessary. And of course, I'm seeking to invite my Lord's attention to the particular section and say why to your Lordships I say that it relates to a reserved matter.
Yes.
I mean, is it in dispute that? Oh, no. Sorry, I'll just leave that.
So we're really looking, are we what relates to, or are we looking at what is meant by the phrase, the purpose of the provision?
Well, I would understand your Lordships may need to consider both.
Yes.
The first, obviously, as my Lord points out, is relates to, and in my submission shortly put, that's a broad expression and deliberately selected as such. And Your Lordships are then looking, of course, at subsection 3 to see how the court may resolve the question of purpose. Now, my Lords will know, by way of background, insofar as this is of assistance, there's some observations made about it in the debate before the House of Lords, and the materials have been, I think, produced for your Lordships from Hansard to say something about the background to that matter. In particular, the statement of Lord Sewell in respect of the possible deployment of the Respection Doctrine in this context.
Sorry, before we go off into things like that, I mean, what do you say here the purpose of the provision is?
Well, I say, Lord, with respect, that the purpose of the provision is to increase the maximum term of imprisonment to 12 months in respect of prosecution on complaint in relation to statutory offences.
So maximum to increase the maximum period of imprisonment. Yeah. Yes, go on.
In respect of statutory offences, my Lord, and I say, I'll come to this if I may in due course, my Lord, but I say that the immediate circumstances of that part of the 2007 Act indicate that the focus is on penalty.
I'm sorry, I've written down the purpose is to increase the maximum sentence in respect to statutory offences.
Yes, my Lord, prosecuted on complaint to 12 months imprisonment.
Yeah, I mean, you couldn't stop short of that, could you? Because it doesn't increase the maximum sentence. That stays for 12 months.
Well, I appreciate, Lord, that that's part of the point that's made against me by the Lord Advocate, but we'll come back to what, of course, your Lordships are looking at in terms of subsection 3 as to purpose, including effect. And I say, Lord, perhaps not surprisingly, if I may, from the appellant's vantage point of view, that the effect, when your Lordships are looking at the effect was to increase the penalty from 6 months to 12 months.
Well, it was. If and when they chose to prosecute with summary.
Yes, of course, appreciate that.
Mr. Chair, I'm old-fashioned enough to think it would be nice to look at the section which we're actually debating. And where is it? Where do we find it in the bundle? Section 45.
Ah, yes, of course, Lord. I'm sorry.
Might be quite nice just to look at it.
It's volume 7, Lord, at tab 82.
Yes.
81.
It's in one of the bound volumes.
It's a bound volume, page 171. I don't know whether it's more convenient. I've got it in Appendix 1, your Appendix 1,
Yes, indeed.
page 171.
I'm obliged, Lord. I should also say, I think it's my fault. It's technically, I think it's in volume 6 of the volume of authorities at tab 82.
Now, 171 is the appendix. And this is, what is this? Criminal Proceeding, etc. Reform Scotland Act. Where does the Act start?
Lord, the Act itself is reproduced in volume 6 at tab 82.
But the title is at page 114.
Yeah.
Sorry, I beg your pardon, that's the wrong page.
It's 130.
130.
Yeah. And as my Lord the Chair observes, it's in the appendix to the bound volume, page 171.
Yeah. And when we look at section 45, we need to look at subsection 1, I take it, and subsection 6.
Absolutely. If your Lordships there have access to section 45, which is the headed other statutory offences, and the Lords will see that the point I alluded to earlier, which your Lordships will see Part 3 of the Act, in which this section appears, is under the heading penalties. And the Lords will see that deals with common law matters, particular statutory offences in Section 44 and other statutory offences in Section 45. And as my Lord the Chair points out, subsection 1 provides that the maximum term of imprisonment to which a person is liable on summary conviction of a relevant offence is, by virtue of this subsection, 12 months.
I mean, I'm just trying to remember back, but I mean, the position before this was that common law offence is 3 months summary, is that right?
Yes.
Statutory offence is 6 months unless there was a specific provision which dealt with the sentence, is that right?
Yes, broadly, my Lord. The common law offences were 3 or 6 months, 6 months if one had a relevant previous conviction.
Yeah.
In respect of statutory offences, as my Lord describes, many statutes prescribing their own penalty.
Yeah. So the effect of this was really to say 12 months for everything.
Yes, indeed, Lord, it was. And as my Lord points out, at least on a practical level, that consistency didn't exist before the Act.
And 44 also, I mean, there were various specific offences. If you thought of constable, you previously could only get 9, but here you are standardising everything, making it all uniform, rounding it up to 12.
Yes, indeed, Lord. I don't think there could be any dispute that that's what the provisions are designed to do.
No, and indeed it appears in the long title at page 133 to make provision as to maximum penalties in the summary criminal court.
Yes, indeed. And as my Lord,
the long title.
With a long title.
And as my Lord the Chair has mentioned already, the background, as fully summarised for the Court's benefit in the Lord Advocate's written case, is the Sheriff Principal McInnes' report, and the legislation is based, at least in part, on recommendations that were made in that report. My Lords will see at subsection 6 of section 45, a relevant offence is an offence under a relevant enactment or instrument which is triable either on indictment or summary complaint and punishable on summary conviction with a maximum term of imprisonment of less than 12 months. Now, my Lords will also see in my submission, perhaps of some significance in this context, that subsection 7 provides that in this section, a relevant enactment is an act passed before this Act.
Yes.
So just so I'm quite clear about this, common law dealt with 43. 44 deals with statutory ones which are triable only summarily.
That's my understanding, Lord, yes.
Well, it's not something I worked out for myself, it's something which I read from the notes, which are helpfully reproduced in the core volume in the other case, in the Miller case, and which describe these sections in section 44. That's how it's described. So that looks as though that's what it does. And then 45 is either way.
Yes.
For instance.
But I do ask, my Lord, simply to notice subsection 7 as well, something I wish I would say something to your Lordships about in due course, but it is there, and on the face of it, relevant enactment does include an act passed before this Act.
Well, it's helpful to have had all that before us now, but coming back to subsection 3.
Yes.
What is the submission then? You're saying the purpose of the provision is to increase the maximum penalties in summary prosecution for statutory offences prosecuted either way to 12 months.
And I say your lordships have to read it in terms of subsection 7, which also directs attention to any act passed before the 2007 Act.
Yes.
And plainly, Lords, that would include, on the face of it, legislation which deals with reserved matters.
I presume if this is right, if you're right on this, then it would probably affect other, I mean, if you're right in the whole appeal, it would affect other acts as well as the Road Traffic Offenders Act.
Yes, potentially, Lord. Going back to my Lord's earlier inquiry about the way matters stood beforehand, for example, Lord, the Misuse of Drugs Act had its own specific penalty for prosecution on complaint, which was 12 months. And so many of the prosecutions obviously are brought under that Act. Well, on the face of it, prosecutions of that character wouldn't be affected, so it would only be a relatively small number of potential reserved matter cases which were prosecuted. But yes, Lord, there would conceivably be some resonance for other matters.
The way the Crown put it is to, I think, accept your definition of the specific purpose, so far as it goes. I'm looking at paragraph 43 of the case in Martin. That the specific purpose is indeed to increase the sentencing powers of a court of summary jurisdiction to 12 months and enable such courts to deal with a wider range of cases. But the impression I get from reading this is that the argument against you is that this is really dealing with the allocation of sentencing powers between different methods of prosecution in Scotland, which is essentially a matter of Scottish criminal law, and is not actually touching on the road traffic law as such, although it may do incidentally. So this is a section 29 2C case rather than a 2B case.
That, Lord, broadly I understand is part of the point which is made against the appellant. Absolutely. Lord, nevertheless, I hope to persuade my Lords that the proper approach in the first instance is to regard it as falling within 2B. For the reasons which are effectively so far canvassed, the fact is that there's no dispute that the territory is reserved matters, and there's no dispute that the penalty has been amended.
May I take it that a defendant was powerless to influence the choice of venue in which she or he would be prosecuted?
Yes, Lord. For all practical purposes.
So I know it would give rise to enormous administrative difficulty. Technically, even under the old legislation, it would be possible for all of these offences to be prosecuted on indictment.
Yes, Lord.
Does that not rather indicate that this is an adjustment of venue rather than an interference with penalty?
Well, I recognise that, Lord, and of course, as I think the Lord and the Chair has indicated, however your Lordships come to apply the tools of analysis to the present circumstances, very crudely put, the Crown position is this is essentially an incidental matter, and the appellant's position is it goes further than that and trespasses on these provisions of the Act, because in my respectful submission to my Lords, there is a stark indication of the penalty in the relevant part of the Road Traffic Offenders Act, which is a matter which is not disputed to be a reserved matter, and it's not disputed that the penalty has been increased.
So if I understand your position correctly, Mr. Shedd, you get the answer to the question simply by looking at the Act itself. It quite plainly is within Schedule 5, because that refers to road traffic legislation. This is a United Kingdom statute dealing precisely with that, and then that means that everything within that Act is a reserved matter and can't be touched by the Scottish Parliament.
Yes, Lord, I'm seeking to persuade my Lords, of course, on the words of the statute, that this, although it may be understandably inconvenient, there may be circumstances in which, in order to respect the proper demarcation between the Parliaments, Westminster simply has to be the body that brings forward the change.
Yes. But there are other examples that occur to one, and I think they've been mentioned in the Kalman report, which is suggestions that Scotland might be able to adjust the Act to allow for different speed limits.
Yes, indeed.
Or a different level of alcohol for drunk driving.
Yes.
But Kalman recognises, I think I'm right in saying that that would have to be done by primary legislation, or the Scottish Parliament would have to be given new powers to do that. And you're saying that the penalties are pari passu with all the other things. Is that correct?
Yes, I do say that, my Lord. I recognise that the background is as set out particularly by the Lord Advocate in her case in terms of the aims of the McInnes review and so on. There's no dispute, Lords, that these are the aims in question, broadly speaking, of course, and there's no dispute that if the submission for the appellant were right, it would give rise to certain practical inconvenience. But, Lord, in my respectful submission, that is the necessary price to pay for a proper interpretation of the provisions, precisely because, Lord, it's necessary in my submission to recognise that when enacting the Scotland Act, Parliament deliberately set out to limit the competence of the Scottish Parliament in certain respects. And so my submission very broadly, my Lords, is to pay proper deference to that scheme. There are occasions in which a challenge of this kind inevitably would be brought and, in my respectful submission, inevitably be well founded. Whether this be the case or not is for your Lordships to judge, but in my submission it's a recognition of the fact that those framing the Scotland Act had in mind that these very particular provisions would be introduced with a view to limiting the competence of the Scottish Parliament.
I mean, going back to the effect of this, as Lord Kerr was saying, I mean, in the past, you would only, or in fact, in any time, you would only prosecute one of these things on indictment if there was some reason to think that it was there was a particularly serious matter for some reason. I mean, the effect of the change is, I suppose, that now a sheriff looking at an offence which is prosecuted, which was just exactly the same offence as would have been prosecuted before the amendment, says to himself, well, this is an offence for which Parliament, or the Scottish Parliament, has now prescribed a maximum penalty of 12 months on indictment, on a summary. And does that in any way, whereas previously, looking at it, he would have said, well, the maximum I can give for this is 6 months. And therefore, I think it's not a terribly bad case. It's halfway up the scale. Halfway up the scale is now 6 months, whereas previously halfway up the scale was 3 months. I mean, is that any part of the argument?
Well, Lord, I'm inviting the Lords to look at the effect, and I say that there's in the legal effect, Lord, if I can put it that way, is that the provisions of the Road Traffic Offenders Act have been modified in this way, and the penalty was 6 months and now it's 12. And in my respectful submission, that's the prime focus. The question that my Lord raises, of course, is effectively, my Lord, goes back to questions of prosecutorial choice, effectively.
Yeah, but I mean, the prosecutor chooses exactly the same venue. But the effect of the change is that something which is a sort of halfway up the scale thing now is halfway up a scale which has got 12 months for it, whereas previously it was halfway up a scale which had 6 months for it.
Yes, I recognise that, Lord. And
it's not a point against you, I don't think, Mr. Sheriff.
You're fearing the gifts.
In fact, not for the first time, Lord Rodger's question prompts a thought directly contrary to the one I expressed earlier. Because, in effect, what he's saying, surely, is you could expect, if you were charged with driving whilst disqualified, to be prosecuted summarily. And in those circumstances, the maximum penalty that you would face was 6 months. Now, you can still expect to be prosecuted summarily, but the maximum penalty you face is 12 months.
yes, indeed, Lord.
And that, you say, is the effect?
Yes.
I mean, doesn't somebody give any sentencing guidelines? I don't know, maybe Scotland, unlike England, has lots of empty prisons, but in this country, on the whole, judges are recommended not to pass longer sentences than strictly they need. And somebody might, following this sort of amendment, have said to the sheriffs, for heaven's sake, of course, you know, you've got an increased power of sentence, but for heaven's sake, remember that you're not actually trying to increase sentences. What you're trying to do is simply deal with cases that earlier might have had to go on indictment.
Well, I think, my Lord, if I could answer my Lord's question, historically in Scotland, such guidance in relation to sentences was given by the appeal court from time to time in appropriate judgments. There is, as I understand it now, proposed a sentencing guideline council in Scotland, which is, I think, not terribly far removed from the position in England and Wales, but as far as I understand, Lords, that hasn't progressed very far with its...
Not in legislation yet.
Not yet, Lord. But as my Lord, of course, identifies part of the difficulty, the Lord Advocate makes reference to some comparable earlier changes in Scotland which allowed cases which had to be prosecuted on the prosecutor's view in the High Court to be prosecuted on indictment in the Sheriff Court because the Sheriff's powers of sentence for indictment were increased. What then happened, my Lord, was a number of arguments in the Court of Criminal Appeal where the primary submission for the appellant was this case would have been prosecuted on indictment in the Sheriff Court before the increase, and therefore what has happened in effect is that the Sheriff has imposed a sentence which exceeds that which would otherwise have been appropriate. So there were a number of practical arguments as a consequence of that kind of change. And it's a reflection, I think, of the point my Lord is just making. In some cases, there will be that kind of argument, no doubt, before the Court of Appeal.
But if the situation was quite as simple as you've been presenting as to the test to find whether the provision is within little b of subsection 2, I'm a bit puzzled as to why one finds subsection 4 in section 29, because 4 is envisaging a provision which would otherwise not relate to reserved matters, and otherwise it fails under B, but makes modifications of, reading short, Scots criminal law, which we know includes penalties, as it applies to reserved matters. Now, one could say that what we're really looking at in section 45 is a provision which is making a modification of Scots criminal law as it applies to reserved matters, which is certainly plain enough because it's dealing with the road traffic penalties. And then you get the qualification, which comes in the next 2 or 3 lines about how one measures up to that. So what I'm suggesting is that the sort of head-on approach which you get in B, while very attractive, doesn't fit very easily with what the section goes on to talk about, which may, on a reading of that provision, subsection 4, seem to be more apt to deal with the case we're looking at.
Well, Lord, I fully appreciate that your Lordships may come to the view that any argument made by the appellants in respect of 2B fails for a variety of reasons in due course, in which case, as my Lord says, the subsection 4 is also to be put into contemplation. But Lord, that appears to operate, as my Lord identifies, only in circumstances where it cannot be said that the provision in question relates to reserved matters.
Yeah. Well, I mean, I think I don't know, maybe my Lord's point, certainly I would suggest that it is necessarily implicit in subsection 4B that there may be legislation modifying Scots criminal law as it applies to reserved matters, which does not fall foul of subsection 2B. It does not relate to reserved matters within the meaning of subsection 2B, because otherwise you don't reach 4B. Do you see?
Yes, I do, Lord. And I don't demur to that either, Lord. As I think the discussion's developed so far, I think this is recognised again by all parties to the appeal, that my Lords look first at 2B, and if that test is met, that's sufficient. If not...
No, quite. But, all right. I mean, maybe I misstated my
No, not at all.
my Lord's point, but I think that's really what it...
I mean, surely what it's saying is that something which otherwise would not be relating to a point of criminal law of Scotland, as my Lord says, but it modifies as it applies to reserved matters. In that situation, it is to be treated as relating to reserved matters. Otherwise, you go back up to 29(2)(b).
Yes, indeed.
And then you're taken out again if the qualification, unless, applies.
Yes, indeed, Lord. It's a deeming provision. It's designed to, as I understand, it's designed to cater for the situation where one does not and cannot to meet the test in 2B of saying the provision relates to reserved matters. Then 4, it requires consideration of the legislation to see whether it's to be deemed as relating to reserved matters subject to those qualifications.
One can see, perhaps, looking at subsection 4, how the argument against you might deal with the point about speed limits, for example.
Yes.
I mean, speed limits is just simply stated. It doesn't, I don't think, well, it's absolutely plain enough. There's no different speed limit for Scotland in the Act as it stands at the moment. It's simply a UK speed limit, generally, according to the type of road you're on.
Yes.
And so it would be difficult to say that that had anything to do with Scots criminal law in the sense that it's dealing with prosecution practice or penalties or anything of that kind, because it doesn't get to that stage. It's simply stating what the offence is. So it may be conceded, I don't know, that that is simply caught by 2B and you don't get into 4 at all. But we're dealing with a situation where it is actually quite plainly setting up a separate system for the Scottish, for Scottish offences under Section 103 to be dealt with the relevant penalties and the relevant venues.
Yes. Now, as my Lord in the Chair points out, the attraction for the appellant in seeking to persuade your Lordships that 2B applies is obvious. My Lords, though, on that analysis need to go further into these provisions. But I recognise, my Lords, that the argument against me plainly is that that doesn't apply, and then your Lordships are looking at the rest of the provisions in whichever order commends itself to your Lordships. Obviously, subsection 4 is relevant because then, as my Lord Rodger points out, one is looking at something which does not meet the test in 2B and therefore may nevertheless meet the test in 4 as set out. And as my Lords point out, 4B, in my respectful submission, is on the face of it applicable to the circumstances of this case if any argument fails in relation to 2B.
Yes.
So what do you mean by that? Do you mean, does it, what's your answer to 4? If
Well,
you're wrong on 2B, what's the answer on what do you say about 4?
Well, my Lord, what I say about 4 is obviously I have to ask my Lords to call attention to that. First of all, as my Lords have observed, this is on the assumption that the matter is not related to reserved matter. 4B makes modifications to Scots criminal law as it replies to reserved matters for reasons which have been touched upon. Lord, my submission on the appellant's behalf is that that is met because my Lords are concerned particularly with the Road Traffic Offenders Act. Then I say to my Lords, obviously, that Parliament then directs that that is to be treated as relating to reserved matters, unless the purpose of the provision is to make the law in question apply consistently to reserved matters and otherwise. And obviously, my Lord, the question then is to analyse that.
What's the analysis then?
Well, Lord, that's plainly a rather difficult question, which I was hoping to come in a moment or so, but I'll come to that now, if my Lord would just allow me to do so.
Well, I don't think we particularly want to take you out of order, but could you give us a snapshot as to what the answer is likely to be when you get to it?
Yes, absolutely, Lord, if I could, if your Lordship would just allow me a moment.
Just whet our appetite.
Yes. Well, obviously, Lord, the starting point for the appellant is that he falls within the section and the proviso does not properly apply. In my respectful submission, Lords, what it is concerned to deal with, broadly speaking, is the situation in which the Parliament legislates to apply the law consistently to devolved and reserved matters.
Not what it's doing here?
Well, I say not, my Lord, for reasons which I'm going to come to. I say that doesn't actually fall within that proviso.
Are you able to just give us a snapshot as to why you invite us to draw that conclusion.
Yes, Lord.
Brown.
Lord, I say to the Lords that...
You could allocate that part of the argument to Mr. Brown, so there's something left for him to say.
I'm sure he'd be only too delighted, Lord, to assist on that matter, since he has taken the time to say something about it directly in his case.
Yes.
And the Lords are aware of that. Lord, I had, to some extent, hoped that I might invite the Lords to look at the matter broadly, similarly to that. And I say that there's a difference, Lord, as I think the learned friend does, between making modifications of Scots criminal law in question, that in this context, the Road Traffic Offenders Act, in order to achieve consistency in the way that it applies to devolved matters on the one hand, and on the other hand, making modifications of reserved matters in order to achieve consistency between the reserved matters and the Scots criminal law in question. So I say, Lord, it's designed to deal with a situation where the law in question applies to both reserved and non-reserved matters. It envisages that situation, but those matters do not apply consistently. I'm sorry, Mills, the law in question does not apply to those matters consistently.
You showed us that modify, that the verb modify is defined in a wide way to include amending or revoking. Would you say modification must be given a similar wide meaning?
Yes, I respectfully submit to Mills that that should be the way.
Because it cuts the other way here. I mean, it's obvious if you're using modification as a restriction that it must also include the still more radical modification involved in repeal or amendment. But here I think it's going the other way, isn't it? That is where the word modification occurs in 29(4). It says
Yes.
amends or repeals
Yes,
Scottish private law or Scottish criminal law.
Yes, indeed, Lord. Yes, I recognise that one. Excuse me. Yes, indeed. Lord, it's perhaps, if I can, Lord, it's obvious to make the point that, broadly speaking, the effect of 29(4) is to expand on the matters which are to be treated as reserved.
Well, I'm not quite sure what you're going to concentrate on now. You're going to develop the argument back at 2B, or if you said all you would like to say on 2B.
Well, if I could say a little about that, Lord, in deference to the fact that I'm inviting the Lords to take that view.
Yes.
I thought I perhaps could do that.
I'm terribly sorry, I'm being a bit confused. Is 2C in play?
2C is in play, Lord, in this context, yes.
So if you lose on 2B and on 2B and on subsection 4, you still got some completely discrete argument is there under 2C?
There is, Lord, yes.
Oh, sorry, there is.
I think, Lord, in fairness, some of the provisions are not particularly straightforward to construe, as might be evident from the difficulty I'm so far having answering all your questions.
I readily agree with that.
It may be helpful to just take them in the order in which they appear. One's got to have,
yes,
like
indeed.
Alice in Wonderland, it's got to start somewhere, and
yes,
might as well
yes,
start at the beginning and go on until you reach the end. But if you take B first, since it appears first.
Yes, well, I'm obliged, Lord. If I can, I'll do that. The basic, if I could just say this, Lord, the basic proposition about 2B, as my Lords have heard from the legislation, is to focus on purpose and having regard to effect. And I think I made very brief reference earlier, Lord, to some discussion in the House of Lords in the debate in advance of the Act coming into force, where observations were made by Lord Sewell, and they are referred to, Lord, in the relevant excerpts from Hansard, which are available to your Lordships. and they are also referred to in various of the printed cases. In particular, I think a helpful passage is set out in the printed case for Mr Miller at paragraph 31. Lords, I think we'll find the Hansard General, volume 7, tab 87.
Sorry, that was volume 7, tab?
Tab 87.
87. Where would it be more convenient to look?
On this point, Lord, in the paragraph 31 in Mr Miller's printed case, Lord, which is in the bound volume.
Sorry, paragraph what of Mr... This is Mr Brown's case in Miller.
It is, that's right,
Paragraph
Lord.
what?
Paragraph 31.
41.
31. Conveniently sets out the excerpt from Hansard.
Yes.
This is all this pith and substance.
Absolutely, Lord.
Yeah.
And certainly I think the Lordships have been favoured with a number of cases from other jurisdictions which might or might not assist my Lords to the resolution of these issues, but my Lords will see for what it's worth so far as this matter is concerned. The observations were made by Lord Sewell in the following terms. The Lords will see that in interpreting what is meant by relates, it's intended the court should rely upon the Responsorial doctrine, which they developed in dealing with cases arising from Commonwealth constitutions and the Government of Ireland Act in 1920. And the classic statement is found in the words of Lord Atkin in Gallagher and Lynn, where he stated, "It's well established you ought to look at the true nature and character, the pith and substance of the legislation. If on the view of the statute as a whole you find the substance of the legislation is within express powers, then it's not invalidated if incidentally it affects matters which are outside the authorised field."
Now, if you applied that test here, would that not be directly against you, Mr Chair?
No, Lord, I'm hoping to demonstrate that when one looks at what Lord Atkin said in his speech in Gallagher and Lytton.
Well, what's the pith and substance of the provision?
Well, looking at it that way, Lord, is, as I respectfully say, Lord, it's in respect of an increase in penalties shortly put, so far as prosecution and complaint is concerned, measured against the fact, Lord, that the subsection, the section itself in subsection 7 is apt to apply to any act whenever enacted. And Lord, in my respectful submission, that inevitably is a reference to acts of Parliament which include acts of the Westminster Parliament on reserved matters.
Is the substance of the legislation not within the express powers, in other words, changing criminal jurisdiction?
Well, I'm recognising, I hope, Lord, that Lords have to construe the words which appear in the section, and there is some room, Lord, I think, for discussion about whether pith and substance doctrine really throws the necessary light on the words in the statute. My submissions are to invite my Lords to the view that the words of the statute are effectively there to provide the guidance the court requires, and therefore looking at the pith and substance doctrine may be only incidentally helpful to your Lordships.
Why are we looking at this?
I'm simply saying, Lord, it's there to assist, if it's any assistance to the court, the background to the matter. But
well, before we leave it, just to look at the last paragraph of the quotation in paragraph 31, Lord Sewell's talking about amendment number 153, which I think is inserting the provision which is subsection 3, isn't it? It's to be determined by reference to the purpose of the provision.
Yes.
He says, well, the courts can determine that a provision is for a permitted purpose, even if, as an ancillary matter, it affects reserved matters. Now, again, it might be thought that that is against you too, because it affects traffic legislation, but the purpose is to adjust the criminal jurisdiction of the sheriff. So
yes.
I mean, that's simply an invitation, really, to read subsection 3 in that way, to find a solution.
yes, Lord, and I recognise that the discussion in Parliament was connected with looking back, as it were, to different constitutional arrangements and doctrines that the court had developed in the context of those constitutional arrangements to analyse the legislation which is before the court in each of those cases and the constitutional arrangements. I'm respectfully inviting the Lord's attention to what 29.3 says, and in my submission, the Lords are looking for purpose, having regard, amongst other things, to effect. But I do say that, and of course your Lordships are invited, in my respectful submission, to focus on the particular provision itself, rather than the scheme of the Act as a whole, necessarily. The material is there for your Lordship's benefit if it's of assistance, my Lord. I had also thought it perhaps helpful to draw attention, if I could, my Lords, to the decision in Gallagher and Lynn itself, if that provides some assistance to my Lords.
But I mean, what's the task we've got? I mean, we've got to stand back, we've got to look at this section 45, and we've got to ask ourselves, in enacting that, what was Parliament up to? What was it all about? What did it want to do? Did it want to lock up people who drove whilst disqualified for longer, or did it want to try and increase the summary jurisdiction powers of punishment of sheriffs? And I don't know, but some people might have thought the latter rather than the former. But not you, Mr. Shedd?
Well, not just at the moment, Lord, no.
Yeah.
I think, as my Lords will know, advocates are sometimes gifted with a measure of optimism in advance of hearing cases, which don't always translate in the hearing themselves. But Lords, my submission, however, is, I hope, my Lords, is going to be relatively shortly put, that my Lords may take some assistance from the observations of Lord Atkins' speech in Gallagher and Lynn.
Where do we find that?
That, my Lords, will find in Volume 1, Tab 22. Volume 2, I'm sorry, I do beg your pardon. Volume 2, Tab 22.
Sorry, Volume 2.
2, my Lord. 2. The Lords will be aware, I'm sure, that the background to the matter was the legislation in respect to the Government of Northern Ireland Act 1920. Lords, they refer to Lord Atkins' speech, my Lords, that starts at 867. If I could take my Lords to 869, if I could.
Yes.
Lords will see that in the second paragraph in 869, Lord Atkin raises the question of the construction of the Act, and his Lordship describes it as the important issue as to the constitutional validity of the Act. His Lordship then calls attention to the terms of Section 4 of the Government of Ireland Act 1920, in terms of which the provisions relating to Northern Ireland remain in force. The Lords will see they're set out, subject to the provisions of this Act, the Parliament of Northern Ireland shall have power to make laws for the peace, order and good government of Northern Ireland with the following limitations. Namely, shall not have power to make laws except in respect of matters exclusively relating to the portion of Ireland within their jurisdiction, or some part thereof, and without prejudice to that general limitation. They shall not have power to make laws in respect of the following matters, in particular, namely, 7, trade with any place out of the part of Ireland within their jurisdiction, except as far as trade may be affected by the exercise of the powers of taxation given to the said parliaments, or by regulations made for the sole purpose of preventing contagious disease, or by steps taken by means of inquiries or agencies out of the part of Ireland within their jurisdiction for the improvement of trade of that part, or for the protection of traders of that part from fraud. It is said that the provisions of the Milk Act interfere with, indeed put an end to, the trade in milk between the farmers of Donegal and the customers in Derry, and that therefore they offend against the express limitations imposed by Section 4. And my Lords, the short answer to this is that this Milk Act is not a law in respect of trade, but is a law for the peace, order and good government of Northern Ireland in respect of precautions taken to secure the inhabitants of Northern Ireland by protecting them from the dangers of an unregulated supply of milk. These questions affecting limitation on the legislative powers of subordinate parliaments or the distribution of powers between parliaments in a federal system are now familiar, and I do not propose to cite the whole range of authority which has largely arisen in discussion of the powers of Canadian parliaments. It's well established you are to look at the true nature and character of the legislation, Russell and McQueen, and the pith and substance of the legislation. If, on the view of the statute as a whole, you find the substance of the legislation is within the express powers, then it's not invalidated if incidentally it affects matters which are outside the authorised field. The legislation must not, under the guise of dealing with one matter, in fact encroach upon the forbidden field. Nor are you to look only at the object of the legislature. An act may have a perfectly lawful object, for example, to promote the health of the inhabitants, but may seek to achieve that object by invalid methods, for example, a direct prohibition of any trade with a foreign country. In other words, you may certainly consider the clauses of an act to see whether they are passed in respect of the forbidden subject. In the present case, any suggestion of an indirect act upon trade is disclaimed by the appellant. There could be no foundation for it. The true nature and character of the act, its pith and substance, is that it is an act to protect the health of the inhabitants of Northern Ireland in those circumstances. Though it may incidentally affect trade with County Donegal, it's not passed in respect of trade and is therefore not subject to attack on that ground. And the Lords will see that that was the...
When he uses the phrase in respect of, is that the equivalent of relates to?
Lord, the expressions are plainly not identical, but they're broadly similar, Lord, and there's some discussion about that, I think, helpfully put in Mr Miller's case, where your Lordships are taking through that analysis. I would respectfully commend that, if I could, to your Lordships, as providing some insight into how this expression should be construed.
But I mean, you commending this to us as the essential approach which is adopted by the draftsman in section 29.
Well, Lord, in my respectful submission, the context is not necessarily wholly the same. What I had understood Lord Atkin to be referring to, as his Lordship says, in terms, is a body of decisions which had arisen in the context of the particularly Canadian parliaments. As I understand his Lordship, he was indicating nevertheless that the true nature and character of the legislation, or the pith and substance test, could be applied in the context of the Government of Ireland Act 1920. There are some similarities between that legislative scheme and the Scotland Act. And so I draw attention to it, Lord, because there may be some value to that, where there's some proper analogy to be drawn one with the other. But I also draw attention to it, Lord, if I may, for the second point the Lord Advocate makes, which is to the effect that your Lordships must be careful to, in scrutinising the legislation, to see that it must not, under the guise of dealing with one matter, in fact, encroach upon the forbidden field. And that may be relevant to the determination of this, a part of the argument. And indeed, your Lordships are then invited also to consider not looking only at the object of the legislation, but also the way in which the legislation is put into operation. So, Lords, I recognise that his Lordship is speaking in the context of a particular constitutional scheme, but there may be some value in these observations to the proper interpretation of the sections in question. Particularly what might be described, if I could put it shortly, Lords, as the objects and methods approach which Lord Atkin draws attention to. Well, I think your Lordships have also had their attention drawn in the bundles to a subsequent decision, Shannon, which is to be found in Volume 3, tab 44, in which...
Sorry, which volume?
Volume 3, Lord, tab 43.
Yes.
It's 43.
43. I think you said 44 a moment ago, but it's 43.
I'm sorry, Lord, I did
Shannon.
It's 43. And, Lord, this is, of course, a case from Canada, but in giving the judgment of the board, the Lords will have seen, I think, referred to at page 719, there is reference to Gallagher and Lynn.
Yes.
In this respect, the Lordships desire to quote a passage from the opinion of Lord Atkin in the House of Lords in Gallagher and Lynn, which was cited by Chief Justice Martin. And then the passage which the Lordships have seen is then set out between 719 and 720. So I just draw it to your Lordship's attention to indicate that the...
So do we get anything more from Shannon, or
No, Lord, it's simply to say that the matter, it being a subsequent decision in 1938, referred back in
But
that
is
context.
Lord Atkin quoting himself, isn't
Yes,
it?
He is, Lord, yes. He is indeed. Lords, the matter was then returned to, I think this is indicated in the printed cases, Lord, in the case of Hume against Londonderry Magistrates, and that's to be found at volume 3, tab 32. And Lords will see that various issues arose for consideration in this case. I would draw attention, Lord, to the judgment of Lord Chief Justice Lowry. And if I could draw my Lord's attention specifically to page 111 first. Lords, this is in the context of reviewing a number of authorities and in reviewing the argument which is then put forward, which is referred to at line 10 on page 111 and following. But the Lords will see at line 25 there's reference there to, again, Lord Atkin's words in Gallagher and Lynn, which are there set out, and your Lordships have seen that. But the observation the Lord Chief Justice made was to this effect: both object and method must be valid, and there is force in the argument that the method employed in Regulation 38.1 is invalid because, and insofar as, it makes use of members of the forces to achieve the lawful object of preserving the peace and maintaining order. And the Lords will see on page...
Where were you reading from just now?
I'm sorry, Lord, that was...
Oh, sorry, I've got it. Yes, I beg your pardon. Yes, thank you.
I'm sorry, Lord, I appreciate it. I'm trying to take the matter a little shorter, Lord. It's hoping it's not distorting the context entirely.
I mean, in a sentence, I don't actually know what this case is all about, but it looks to be about use of soldiers. How does it work? What was the issue?
Basically, Lord, we'll see, perhaps the easiest way, if I can draw my Lord's attention to it briefly, is to look on to page 115, Lord, where the Lord Chief Justice's conclusions on the matter are summarised at paragraphs 1 to 6. It was giving powers, Lords, to members of the armed forces as opposed to police officers, broadly speaking. Lords, will see summarised in those propositions the words "any commissioned officer of Her Majesty's forces on duty" and "any member of Her Majesty's forces on duty" are descriptive of subject matter within the forbidden field comprised in section 413 of the 1920 Act. Regulation 38 is a law in respect of that subject matter. The words "in respect of" have the same general meaning throughout section 4.1 and are nowhere confined to the imposition of burdens, controls or obligations. That's an objection of an argument advanced by the Crown. The intention of the legislature is to be derived from the words of section 4.1. The reference to the forbidden subject matter is not a matter of incidental effect as defined in Gallagher and Lynn, but is an example of the achievement of a lawful object by invalid methods. And even though Regulation 38.1 is in respect of the preservation of the peace and the maintenance of order, it is also, by virtue of the powers conferred on officers and members of Her Majesty's forces on duty, in respect of the subject matter included in paragraph 3 of section 4.1, and to that extent contravenes the limitations thereby. So, the Lords will see, just taking proposition 6 for the moment, in that case at least the conclusion was that although the regulation was also in respect of preservation of peace and so on, it was also in respect of the subject matter which is referred to in paragraph 3 of section 4.1, and to that extent contravened the relevant limitation.
In other words, the object was, one of the objects, the preservation of peace, that was something which the Northern Ireland Parliament had power to legislate for, whereas the other matter was not.
Yes, indeed not.
And where is paragraph 3 of section 4.1 to be seen?
It's summarised in the head note at page 91.
Yes, it's probably the best way
basically
from
the armed
here.
forces of the Crown.
Yeah.
Yes, indeed. I'm most obliged, Lord. Thank you.
And the holding sets it out quite neatly on page 92, I think.
Yes, I'm obliged, Lord. Perhaps I should have taken Lords to that. The Lords will see that, reading from the second paragraph on page 92, the convicted persons applied to the High Court to quash the convictions read short that, first, having regard to section 413 of the Government of Ireland Act 1920, it was outside the competence of the Northern Ireland Parliament and of the Minister who purported to make the regulation to confer powers on any member of Her Majesty's forces on duty acting on his behalf. Secondly, that Regulation 38.1 did not conform to the powers of the Northern Ireland Parliament or Executive under the 1920 Act to make laws for the peace, order and good government of Northern Ireland, or to the power of the Minister of Home Affairs under Section 1.3 of the Civil Authorities Special Powers Act Northern Ireland 1922 to make regulations for the preservation of the peace and the maintenance of order, because it was not conducive to peace, order and good government, or in particular to the preservation of the peace and the maintenance of order, and because it was excessively far-reaching and oppressive. And it was held that the provisions of Section 4.1 of the Act, which impose the limitation that the Parliament of Northern Ireland shall not have the power to make laws in respect to the matters set out in that subsection, precluded the making by the Minister of a regulation under the Civil Authorities Special Powers Act Northern Ireland 1922, which purported to confer powers on officers and members of Her Majesty's forces on duty.
And how do you say we should apply that decision in this case, having regard to the way the legislation is set out in the Scotland Act?
Well, I respectfully draw attention to it, my Lord, because it appears that there's support, at least in this decision, for looking at the objects and methods as part of the analysis. And that is one matter which your Lordships could regard as helpful in construing Section 29, subsection 3. And in Proposition 6 on page 115, my Lords see that the matter may have more than one aspect, one of which trespasses on, in this context, a reserved matter, or as more broadly described sometimes, the forbidden field. And if so, that may be sufficient for your Lordships to reach the conclusion.
We might put the argument somewhat simplistically in this way. The Parliament of Northern Ireland was empowered to pass legislation for the peace, order and good government of Northern Ireland. It purported to confer powers on members of the armed forces in order to achieve that object. But it was forbidden by Section 4 to legislate for Her Majesty's armed forces. And therefore, although it might be said that the object or the purpose of the legislation was within the legislative competence of the Parliament, in that it was for the peace, order and good government, the means by which it purported to effect that objective was forbidden by Section 4.
Well, I'm very much obliged to your Lordship. That's the point I was endeavouring to take from the matter, Lord. And of course, Lords may, and indeed in my submission are, concerned with a particular provision under scrutiny, which is Section 45, and I've drawn my Lord's attention to the fact that there is reference in that to any enactment passed before the Act. And in my respectful submission, Lord, that is an express, albeit indirect, reference to the forbidden field. So in my submission...
You mean by that it's an express reference to, inter alia, the Road Traffic Act?
Yes, indeed, Lord.
Yes.
So, Lords, I respectfully suggest that those observations could be taken from the observations, particularly of Lord Chief Justice Lowry in that particular case. I've already addressed your Lordships of what I respectfully submit your Lordship should see as the object of the legislation. It was described as purpose, but I asked my Lords to look at it also in terms of object and method. I've dealt with briefly the question of object. Well, the question of method, in my respectful submission, would be by amending the specification of the maximum term of imprisonment in the penalty provisions of the relevant statutes.
Yes.
And as my lords, I think, will have seen from some of the matters which are discussed in the authorities, there may be two other questions which would be of some assistance to your lordships. The first would be, is section 45 in respect of a matter within the authorised field? Obviously, I would invite my lords to answer that question in the negative. The second question was, does it purport to legislate in respect of a subject matter outside the authorised field? And plainly, I would invite my lords in this branch of the argument to answer that question in the affirmative. And I ask my lords to do that in part because of the reference in subsection 7 to relevant enactment. And as I respectfully invite the lords to the view, that makes express reference to the forbidden topic, albeit it's indirect.
Well, is that pretty well everything you want to say on subsection 2b read with subsection 3?
Yes, Lord. I'm obliged.
And is it best then to go to Schedule 4? Because it looks as though that should come in before one looks at subsection 4, really, because one wants to know whether
Yes, indeed.
little c is satisfied.
Yes, indeed. Therefore, if I can invite my lords' attention again to the relevant provisions of the schedule. They are found on page 71 of the Scotland Act.
Sorry, where are we going to?
Lord, it's in volume 9. It's
Oh, no,
schedule.
no, but haven't we? Yeah, that's right. Page what?
It's page, particularly page 71, Lord. It's schedule 4 to the Act.
I see. All right.
The Lords have already had cause to notice the particular provisions. Lord, perhaps I can try to put it into context of the present case, if I could.
Yes, please.
And ask my Lords to take 2.1 and 2.2, read them together, and reading them short in the present context. I say, Lord, what that produces is this, that an Act of the Scottish Parliament cannot modify any enactment, the subject matter of which is a reserved matter.
And we know from the definition section that includes amendment.
Indeed, Lord. So I respectfully submit, Lord, that the relevant part of the Road Traffic Offenders Act, which your Lordships are most concerned with, comes within that definition.
So that paragraph was which one you were just reading just now?
Lord, I was reading 2.1 and 2.2 together.
2.1, thank you. Mm-hmm.
And reading short, Lord, as I were, to try and put it in the present context. But, Lord, I recognise that the but comes now, as it were, but the restriction applies only to the extent that the rule is special to a reserved matter. And the Lords find that in subparagraph 3.
So we are dealing, are we, with a rule of Scots criminal law?
Well, in my submission, your Lordships are, and that comes again, Lord, from the definition, the interpretation section of section 126, subsection 5, which includes in the context of Scots criminal law penalties.
I'm losing the plot at the moment.
I'm sorry, Lord, it's my fault.
No, I mean, I follow what you just said, but
as I understand it, Lord, the structure, I was simply trying to read it short, Lord, but the structure is to start with the restriction on the Scottish Parliament not modifying the law on reserved matters, which is obviously a phrase deliberately selected, and the Lords will see that the law on reserved matters is then effectively defined in 2A for present purposes, which is effectively statute law, and B, as I would understand it, is effectively common law rules. And those matters are then brought together in subparagraph 3 to say that the prohibition applies in this context only to the extent that the rule in question is special to a reserved matter.
So can I just see if I follow this, that you accept that in order to understand 2.1, you have to go to 2.3, because we're dealing with a rule of Scots criminal law, because we're looking at penalties for Scotland. That's fine. And so paragraph 1, subparagraph 1 applies only to the extent the rule in question is special to reserved matter.
Yes.
Now, how does one determine whether that is the case or isn't in the case of section 45?
Yes, indeed, my Lord. That is obviously, if I may say so, the next question, or what meaning have your Lordships to give to that expression?
Yes.
As I understand it, my Lord, the expression is not defined in the Act itself, unfortunately. But I would submit, I think in common with the co-appellant, that some guidance may be derived from the explanatory note to the Act, which, as I understand it, Lords would find at Volume 8, tab 106. It is also, Lord, conveniently set out, perhaps more readily for your Lordship's benefit, in Mr. Miller's case at paragraph 55. And, Lords, this may be the, if I may say so, maybe a convenient way to look at the matter for your Lordships. First at paragraph 55 of Mr. Miller's printed case. Lords will see there is reference to at page 200, the explanatory note. Lords will see it says subparagraph 3 provides that the restriction on modification applies to a rule of Scots private or criminal law only to the extent that the rule in question is special to reserved matter, a rule which results in a distinct and separate treatment of a reserved matter, and to other specified aspects of private law.
Special is often used in contradistinction to general, and that seems to me the most natural meaning of it here, isn't it?
Well, I acknowledge the force of that, Lord, certainly. The Parliament plainly didn't think it necessary to provide a particular definition, Lord, but I would respectfully submit that that guidance is perhaps of some assistance to the Court. There's also in paragraph 56 of the printed case reference to statements made by Lord Sewell, again reproduced in Hansard. The references are there given. And perhaps I could just draw my Lord's attention to that briefly, if I could.
Where are we? Sorry.
Paragraph 56.
This is
56,
the next paragraph,
yes.
my Lord, for convenience.
Okay.
It's also in the Hansard, which is more fully reproduced in the volumes. But the reference is there given at paragraph 56, my Lord, and there is something said about this topic. And perhaps I could just simply read that to my Lords. The new test in Schedule 4 applies generally. In the case of Scots private and criminal law, however, it applies only to certain specified aspects of private law and to the rules of Scots private and criminal law which are special to reserved matters, those which result in a distinct and separate treatment of a reserved matter. In the latter case, the rules will include not only those which exist at present, but also any private or criminal law provisions in future Westminster legislation, which are special to reserved matters, and which would, of course, supersede to that extent any general provision of Scots private law. And then my Lords may see that reference is made to particular examples, and the first is Section 90 of the Copyright Design and Patents Act of 1988, which categorises copyright as movable property and provides that an assignation of copyright is not effective unless it's in writing signed by or on behalf of the assignor. This is a special rule of Scots private law in a reserved matter designed to protect the interests of an owner of copyright. Secondly, in the case of betting, gaming and lotteries, the rule that gaming contracts cannot be enforced on the basis that they are on ludicry, and thirdly, the provisions of the Proceeds of Crime Scotland Act, which make special provision about confiscating the proceeds of drug trafficking. So those are the examples which were there referred to.
I'm trying to sort of cross-relate this whole Schedule 4 with subsection 4 of Section 29, which also deals with modifications of Scots criminal law, and then with the proviso that it's okay as long as it applies consistently to reserved matters and otherwise. I mean, there seems to be something of the same thinking, but I don't see how they interrelate if at all.
Lord, it has been, as I understand it, suggested that Lords might care to apply their judgment to the schedule in relation to the particular question which I'm seeking to address at the moment, Lords, that is whether the provision is special to reserved matter. If I fail to persuade your Lordships that that was the position here, then nevertheless, Lord, I would be arguing that Section 29(4) would still have to come into contemplation. So I invite Lords to take that view, and if I do so, Lord, it's been contended that that's the proper approach, Lord, and I simply draw attention, Lord, if I could at this stage, to the Lord Clyde's book on judicial review, which the Advocate General has helpfully produced in a supplementary bundle of authorities for your Lordship's benefit.
I mean, what is the rule in question here?
The rule in question, Lord, in my submission, because this is effectively trying to read paragraphs 2A and B together, which contemplate different situations, one statutory, one common law. In my submission, the rule in question is the penalty contained in the Road Traffic Offenders Act.
Well, is it? It's said against you. I'm looking at paragraph 54 of the Lord Advocate's case, that we're looking at a maximum sentence of imprisonment, which really is inherent. I think it's to be found in the Criminal Procedure Scotland Act. I may be wrong.
Yes.
The maximum sentence available on summary procedure prior to the amendment I'm talking about was a rule that was not special to the Road Traffic Act at all. It was one that applied generally to all statutory offences, and examples are given in the Lord Advocate's case of statutes such as the Civic Government Scotland Act, the Protection of Wild Animals Scotland Act, Sexual Offences Act, and so on and so forth, which are not reserved. And therefore we're dealing with a statutory maximum which applies across the board to both reserved and not reserved statutory offences.
Well, Lord, I certainly appreciate the point that is raised against me in relation to this part of the analysis, Lord. While there seems to be much general agreement about the stages of analysis your Lordships have to undertake, conceptually, of course, the parties all differ about the outcome. Lord, what I'm saying to my Lords with respect is that it is right in the context of Schedule 4 to analyse the matter in this way, that the rule in question, to answer I think the Lord Brown's particular question, can be regarded as the penalty provision of the Road Traffic Offenders Act. I say that, Lords, because paragraph 2A deals with the question of statute, but paragraph 2B deals with any rule of law not contained in an enactment and the subject matter of which is a reserved matter. And so that contemplates, in my submission, a common law.
But Lord Brown's general observation and question, I find totally baffling. Why Parliament seems to have set up two sets of hurdles, which are both a bit like each other, but not exactly like, and you've got to negotiate both of them. One is Section 29, the other is most of the paragraphs, but not all the paragraphs of Schedule 4. And one finds they seem to have similar sort of ideas. The reference to special in Schedule 4, paragraph 2, has a sort of counterpart, the reference to consistency in 29(4), because consistency is what is general. But why it's all been set out twice in different language is absolutely baffling.
Well, Lord, if I were immediately able to assist your Lordship with precisely why that was so, I would try to do so, Lord. But what I would, in tempting to do, to answer my Lord's observation. I think it's perhaps helpful to remind my Lords that 29.4 relates to Scots law generally as it applies to reserved matters. Whereas it might be said, Lord, that Schedule 4.3 more naturally relates to provisions enacted by the United Kingdom Parliament with reference to Scotland. Lords, I have alluded to this, and the Advocate General has helpfully provided it. Lord, perhaps I could just draw my Lord's attention to that at the moment. The book by the Right Honourable Lord Clyde and Mr Edwards, Judicial Review, an excerpt for which is helpfully produced in a supplementary bundle of authorities, my Lord, and with apologies to my Lord Brown, I think that makes 11 volumes, at least.
I found that.
Which one? 11?
It's, Lord, although there's maybe not immediate assistance, it's a slender volume, Lord, supplementary bundle of authorities produced by the Advocate
Number
General.
10, which is relatively slim, but I can't
Yes, I'm sorry, Lord, that's mine, I'm afraid,
I can't find anything
to counter an earlier omission.
I don't think we've got anything slender, no.
Oh, it's on the side.
Oh, yes.
Behind it.
Yes, it's got a different type of cover. Yes.
Well, it's just called, so we haven't got a number, it's just called supplementary bundle. But we're going to call it 11, eh?
So it's tab 4 in that bundle, is it?
It is, Lord, yes.
Which bit of it?
Lord, the learned authors deal with the law and reserve matters, the effective Schedule 4, at page 288 and 289, at paragraph 7.19. Now, Lords will see that the paragraph 719 begins with a statement of the provisions themselves. And having done that, Lords, that takes me, Lords, I think, to footnote 5, and picking up the matter from there, which is about half a dozen lines or so into the paragraph, it said, but in relation to rules of Scots private law and Scots criminal law, which form part of the law on reserved matters, Schedule 4, paragraph 2.3 contains an important qualification, the effect of which is to make some saving of the Scottish Parliament's competence to modify rules of Scots private law and Scots criminal law, except where the rules in question are special to a reserved matter. The Scottish Parliament has competence to modify the rules. However, the Scottish Parliament's competence over the modification of Scots private law and Scots criminal law still remains subject to section 29.4, which, as noted above, restricts the Parliament's competence to modify Scots private law and Scots criminal law as they apply to reserved matters, unless the purpose of the modification is to make the law apply consistently to reserved matters and otherwise. Accordingly, the Parliament's powers over rules of Scots law which do not form part of the law on reserved matters, because they are not special to reserved matters, must still satisfy the conditions of section 29.4.
Well, Lord Clyde finishes that little chapter by saying it remains to be seen how these somewhat convoluted provisions are going to be translated in practice.
Indeed,
He's no
Lord.
doubt watching with great interest to see where we go next.
Well, Lord, hoping, Lord, I have sufficient generosity to acknowledge my sources, Lord, with respect, I would suggest, Lord, that the point which the learned authors make is a sound one in this context, Lord, that even if...
What is the point, so as I know whether it's...
I'm sorry, Lord, this particular point, Lord, even if I were not to persuade your Lordships that the rule in question is special to a reserved matter, the authors suggest that nevertheless the matter has to be, in appropriate circumstances, subjected to the analysis under section 29, subsection 4.
really takes us back to
Yes, it
29.4.
does, really. So we'd really go back now to the section.
Yes,
I
indeed.
mean, are you contending it's special, Mr.?
Yes, I am, Lord.
You are? Oh,
Yes, I am, Lord.
okay.
I'm seeking to do that relatively briefly, Lord, both for, I think, the...
Well, I understood you to say it's special because it really it's plain from looking at the schedule in the Road Traffic Offenders Act itself, because that's where the thing is set out, and that's exactly what is the subject matter of Section 45.
Yes, indeed, Lord. I think there's a distinct and separate treatment of a reserved matter, that is the penalties, which were applicable in Scotland as opposed to England and Wales, and in respect of the way in which matters are particularly set out in the schedule to the Road Traffic Offenders Act. Because, my lords, of course, are being invited to focus on the penalty for this particular offence.
I mean, do we have to consider paragraph 3 as well?
Yes, indeed, Lord. That then comes into the... yes, I appreciate, Lord, it's not necessarily most straightforward, but, Lord, if the appellant can persuade your lordships that these provisions are engaged, then he needs to invite your lordship's attention to paragraph 3. And the lords will see that paragraph 2 does not apply to modifications which are incidental to or consequential upon provision made, whether by virtue of the act in question or another act which does not relate to reserved matters, and do not have a greater effect on reserved matters than is necessary to give effect to the purpose of the provision.
Paragraph 3.
And what do you say about that?
Well,
it doesn't apply if this is a modification of that character, and it's set against you. I think, well, it is of that character.
yes, indeed, Lord, and I'm afraid, Lord, like so much of my submission, I seek to invite my lords to reach the opposite view. My learned friends, Mr. Brown and Mr. Devlin, have assisted my lords by setting out dictionary definitions of incidental and consequential in their printed case, Lord, and they're there, and I respectfully invite my lords to have regard to those insofar as they're of assistance. And lords, again, my lords will see that the matter is also discussed in Clyde and Edwards. And that, my lord, particularly at page 289, my lords will see where the learned authors are dealing with this part of the Act and the schedule. My lords will see that, again, references made to the provisions, which I think takes my lords again to footnote 7 or 8 lines down, and then the authors say this: on its terms, Schedule 4, paragraph 3 concerns only modifications of the law on reserved matters, and not provisions passed by the Parliament, which do not amount to modifications of the existing law, nor modifications of Scots private law or Scots criminal law as they apply to reserved matters. But insofar as it applies, the effect of paragraph 3 is to introduce a form of proportionality test into the assessment of the incidental effects of otherwise competent enactments of the Scottish Parliament on reserved matters. Where such effects on reserved matters are proportionate in terms of section paragraph 3.1b, the provision will not be treated as modifying the law on reserved matters. Equally, where the effects on reserved matters are disproportionate, it will be so treated. By virtue of paragraph 3, courts must weigh the purpose of a challenged provision, understood by reference to Parliament's competence, against the nature and severity of its impact on reserved matters. In short, if the purpose is lawful and the effects are not too bad by reference to the need to achieve the purpose, the provision will be competent. It may be that such an approach will come to be applicable generally in determining the proper scope of the Parliament's competence as it relates to reserved matters.
There are 2 steps in paragraph 3, aren't there? Subparagraph 1. First of all, you've got to find out whether this is a modification, i.e. an amendment, which is incidental to or consequential on a provision made which does not relate to reserved matters, and your fundamental point is that it's perfectly obvious it does relate to reserved matters,
Yes.
and therefore the Lord Advocate has to fail under A anyway.
Yes.
But assuming he can succeed, then the question is, under B, does it have a greater effect than is necessary to give effect to the purpose? And that's more difficult for you, isn't it? Because if the purpose is to adjust the jurisdiction of the sheriff's sentencing powers, it's simply doing that. It's not going any further than is necessary to achieve that.
Yes, I recognise that, Lord.
So it would have to be, your argument is really on 3.1a, isn't it?
Yes, my Lord, principally. I make certain other observations on the appellant's behalf in the printed case, my Lord, but I do recognise the force of my Lord's point about the matter.
So proportionality isn't really in point here. It's really either yes or no to 3.1a, I would have thought.
Yes, my Lord, and I submit it does meet that test, the rule apply. Well, I suppose, my Lord, I should qualify that a little. The structure of the paragraphs in Schedule 4 do direct your Lordship's attention in sequence to these questions. And of course, if my Lords arrive at the point where it's a rule of Scots criminal law read shortly, which is special to reserved matter, then my Lords are looking at paragraph 3. And then the analysis would come into play. But I would respectfully commend these observations, my Lord, by the authors in question, because it may be of some assistance to your Lordships in looking at what paragraph 3 in relation to these two matters law is designed to do. And the point which has been made, I think, in the printed cases, my Lord, is that the provision is only saved if both of those matters are met. That is 3A and B.
Yes. Well, we have to go back to section 29.4, do we?
Yes, we do.
And we have to proceed here on an assumption that you failed so far, and this is a provision which would not otherwise relate to reserved matters.
Yes.
But it is making a modification of Scots criminal law as it applies to that, which, on the assumption one's proceeding on, you would accept, I take it.
Yes, I would. And then the Lords will see that that is, in effect, a deeming provision which says that these matters being assumed, a provision within an Act of the Scottish Parliament is to be treated as relating to reserved matters, unless the purpose of the provision is to make the law in question apply consistently to reserved matters and otherwise. Now, there, my Lords, again, if I could just mention to the Lords, there's some discussion of this in Lord Clyde's textbook, Scots Law and Reserved Matters, the effect of section 29.4, Lords, and that's at page 287.
287?
287, Lord. Now, Lords will see the learned authors say that a key problem for the competence of the Scottish Parliament is to what extent an Act of the Parliament, the purpose of which does not relate to reserved matters, goes beyond competence because of its incidental effect on reserved matters. Beyond section 29.3 of the Act deals with this problem by reference to the Parliament's competence in relation to Scots law and the law on reserved matters. In effect, the Scotland Act provides that the law on reserved matters is reserved. The Scottish Parliament has in general no power to modify it. In contrast, Scots private law and Scots criminal law are not reserved. The Scottish Parliament, again in general, has power to modify them. But this apparently simple dichotomy will inevitably hides great complexity. First, the law on reserved matters will inevitably include rules of Scots law. Therefore, some rules of Scots law are reserved by operation of Schedules 4 and 5. Secondly, even where rules of Scots private law and Scots criminal law do not form part of the law in reserved matters, modifications of those rules may affect reserved matters or the law on reserved matters. For example, a reform of the ordinary law of contract may have some effect on reserved employment law. The Scotland Act attempts to deal with these difficulties in section 29(4) and schedule 4 to the Act. The Act deals distinctly with modifications by the Parliament of the law on reserved matters, the subject of schedule 4 discussed, as my lords have seen, and modifications of Scots private law and Scots criminal law as they apply to reserved matters dealt with by section 29(4). And the lords will see that then there's reference to the provisions of section 29(4), and including the expression that your lordships are presently engaged in considering. And the learned authors suggest on page 288, accordingly, even though a provision in an Act of the Scottish Parliament modifying Scots private law or Scots criminal law does not otherwise relate to reserved matters, section 29(4) means it's to be treated as doing so unless its purpose is to make the law apply consistently, and so on. While section 29(4) appears to apply only to apply to modifications of Scots private law and Scots criminal law, and not, for example, restatements of existing law, its effect is clearly to expand the matters which are reserved and therefore beyond the competence of the Scottish Parliament. Beyond this, however, the effect of section 29(4) is less clear. For example, it may be questioned how different is the term applies to reserved matters from relates to reserved matters, or what is to be understood by consistently in this context. In relation to consistency, consideration may have to be given to the direction in section 29(3) to effect in all the circumstances, to the idea of proportionality expressed in schedule 4, as my lords have seen, or to the question whether the modification effected by a provision must also satisfy the conditions of schedule 4.
Well, if we look at the language of subsection 4, after little a and b, we're asked to consider the purpose of the provision.
Yes.
And is it right to think that takes one back to section 45? That would be the provision.
Yes, it would. That is the provision under consideration, Lord.
Mm-hmm. And what is its purpose?
Lord, the purpose is not defined specifically as it is in subsection 3, but it may be that your lordships will conclude that there's some assistance to be derived from the wording of subsection 3 in looking again at the question of purpose when it appears in subsection 4.
Well, it's perhaps slightly narrow here because all one's being asked to consider is whether it is to make the law in question apply consistently to reserved matters and otherwise.
Yes.
And is the fact that section 45 is in really quite general terms a pointer to the answer to that question?
Yes, Lord. I think I see the force in that, Lord. The one difficulty of potential interpretation, Lord, is looking at the expression apply consistently to reserved matters and otherwise in this context. Lord, what I submit, Lord, is that appears, given the other sections in the Act, to envisage a situation where the law in question applies to both reserved matters and non-reserved matters, but it does not apply to each of them consistently.
But you mean to the previous law, or do you mean the...
Yes.
You're suggesting that it's contemplating a situation where there's, as it were, an imbalance between the two.
Yes.
And it's trying to bring them in balance.
Yes, indeed, Lord.
And you're saying that's not what section 5 is doing. Is that right?
It is. That is my position, Lord, yes. Plainly, the laws are contemplating restrictions in in all of these sections and schedules on the power of the Scottish Parliament. And generally speaking, Lords, it's plain that the Scottish Parliament cannot legislate for reserved matters. So, as is suggested in Clyde and Edwards, these are restrictions on the power of the Scottish Parliament to legislate, and they have to be seen in that light in my submission. And viewed in that light, Lord, it would be clear that the Parliament should have some flexibility to bring matters, to deal with matters, to bring them into line, Lord, but not, as it were, to reflect back upon matters which are properly reserved, because those were matters which, on a direct approach, the Scottish Parliament could not legislate for.
I just missed that. What was
I'm sorry, Lord, I didn't perhaps put the matter very clearly, but plainly, Lord, the scheme of the Scotland Act generally is to identify reserved matters which cannot be legislated for directly by the Scottish Parliament. And so, on the other hand, Lord, plainly these provisions have in mind, to some extent, I think this has been pointed out in the written cases, as well as a fetter on the power, it also provides a facility whereby the scheme isn't applied too rigidly, to permit the Scottish Parliament to take certain steps which would not otherwise trespass on reserved matters.
I mean, 4 is basically designed to ensure that the Scottish Parliament, under the guise of general legislation on private law and criminal law, doesn't legislate on reserved matters. I mean, that's its main purpose. The unless bit is to carve out an exception to that and say that that doesn't apply. That fetter which they're putting on it doesn't apply, where the purpose is just to make the law apply consistently on both sides, isn't it?
Yes.
So it's an exception to a general prohibition.
I don't in any way demur to my Lord's proposed analysis of the matter, but I say, my Lord, that provides, if I may, a slightly greater illumination of this scheme, because these are all about the restrictions on the power of the Scottish Parliament generally to legislate on reserved matters. But to draw that line too brightly would no doubt produce unwelcome inflexibility so far as the Scottish Parliament was concerned. But that's why I respectfully submit, Lord, the matter should be seen in the way that I've broadly suggested. So crudely, very crudely put, Lord, it could be regarded as something of this, being within the Scottish Parliament's power to embark upon a tidying up exercise to achieve consistency.
It can tidy up to achieve consistency, but not reform to alter what is in the legislation there, and was in itself not inconsistent before the Parliament got to work on it.
Yes, indeed, Lord.
And it had legislated first in one way and then tidied up afterwards.
But I respectfully submit, Lord, with assistance of the observations my Lords are making just now, that that's entirely consistent with the overarching scheme of this part of the Scotland Act. Mm.
Well, have you just about completed your submissions, Mr. Chairman?
Yes, more or less.
So you've really reached the end of these provisions. There's nothing else once we reach subsection 4, having gone through schedule 4.
Yes, indeed, Lord. And in an effort, vain effort to impose some order on what I was proposed to say to your Lordships, I thought I would deal with section 101 last, but your Lordships have already asked me to say something about that, and it's not contentious, Lord, I think, amongst the parties. My Lords, the different formulations, my Lord, in respect of how your Lordships might approach section 101(2) should it arise. Lord, and if I can just simply give my Lords the references to those. In the appellant's case, that is paragraph 56. In the co-appellant's case, paragraph 122. In the Advocate General's case, paragraph 72. In the Lord Advocate's case, paragraph 61. But I don't detect any fundamental difference on the approach.
Could you give the paragraph numbers again? The appellant's case is 56.
56, Lord. The co-appellant's case, 122.
Yes.
Advocate General's case, 72. Lord Advocate's case, 61.
Thank you. Yes.
Lord, there's only one other matter that perhaps arises immediately, Lord, if I could just raise it. The Lord Advocate raises the question of Section 102 of the Scotland Act in her case, which, in my submission on any view, raises an important issue.
This is whether we should postpone any order we make. Is that right, to give an opportunity for something to be done about it?
Yes, indeed, Lord. And if my Lords would permit it, I wouldn't wish to get drawn into the matter at this stage. It may be I wish to say something to my Lords in due course if the Advocate Depute addresses the matter. It is, in my submission, conceivably a difficult topic which perhaps couldn't be adequately debated in the time available. And on one view, in any event, Lord, it could be regarded as academic for present purposes, since the Crown acknowledge that if the present appellants are correct, then no such restriction should apply to them. Yes.
Well, it's better, I think, perhaps we should hear from the Advocate Depute, and you would have a chance to comment on his submissions, if appropriate.
Yes, well, I'm most obliged, ma'am.
Thank you very much, Mr. Shedd. Mr. Brown, we look forward to hearing from you at 2 o'clock.
Oh, yeah, that's right.